Yes.
Your Lordship, may I make a mention regarding item 8 of part 2, hearing list. The reason why it is listed is, as per the last court's order, this is for whether it has to be sent for mediation.
Okay.
So both the parties had agreed. Mr. Lalfuma could not come today, but I have spoken to him this morning.
Okay.
So this may be sent to mediation, ma'am.
Mediation. Okay. Part 2(8). Heard Mr. Villaramena, learned counsel for private respondent number 1, who submits that he has been informed that both the parties are willing to have the matter referred to mediation. In view of the above, matter is to be sent for mediation instead, then registry to do the meeting.
My Lord, item 8 and 9, sorry, my Lord.
Okay.
These are tagged together.
So both the
Both the cases. Much obliged.
May it please your lordship, I seek your lordship's indulgence in mentioning part 2, item number 13.
Yes.
I've taken the consent of the opposite party, your lordship, if this matter may be listed again after a week, after the ensuing vacations, your lordship.
Vacation.
Yes, your lordship.
Heard Mr. Luntui, learned government advocate for the state respondents, who has prayed for adjournment of the matter with the consent from the other side. In view of the above, list after the ensuing vacations.
Much obliged, your lordship.
I seek your lordship's indulgence in mentioning item number 5, 6, and 12 of part 2. Lordship, my senior Mr. Johnny has some personal difficulties and has submitted his leave of absence. If this matter may be taken after the vacation, Lordship.
Have you spoken
Yes,
to the
Lordship.
councils from the other side?
Yes, Lordship.
You have? Mention is made on behalf of 5 and 6 is?
5, 6, 12, and 12.
Okay, now for 5 and 6, it will be the same order. Mention is made on behalf of Mr. Johnny L. Tochong, learned counsel for the appellant, for adjournment of the matter with the consent from the other side. In view of the above, list after the ensuing vacations. Then 12, mention is made on behalf of Mr. Johnny L. Tochong, learned counsel for respondents number 1 to 4, for adjournment of the matter with the consent from the other side. Then same, just after the vacations. Yes.
Much obliged.
Motion, item 1.
Yes, what's the matter about?
So, my lord, here is a matter, my lord, where the petitioner, who has been appointed, my lord, as a gatekeeper under the Directorate of Geology and Mining, my lord, at Bhairavi, he has been relieved of his service, my lord, by the respondent number 4, only through a simple telephone call, my lord. And he was informed that the respondent number 5 is now appointed to work in his place. Now, this happened in the month of July, and since July, the respondent number 5, my lord, has been working in his place. So we are challenging the action of the respondents number 1 to 4, my lord. And if your lordship will come to page number 17, my lord. This is his appointment letter,
1-7?
1/7, my lord. I'll read, my lord. In pursuance of the approval of the DP and ARW Government of Mizoram filed their ID number so and so dated, and concurrence of Finance Department Government of Mizoram filed their ID number so and so, conveyed by Commerce and Industries Department Government of Mizoram filed their ID number so and so, the dated, and with the erection of mining check gates at Zolnuam, Bhairavi, Kolasib, Rengtekon, and Vairengte, the following persons are hereby selected as local laborers, casual employees in semi-skilled, as these check gate persons are to be able to interpret the Mizoram Mining Mineral Concession Rules 2000 as amended and the monitoring system for mining check gates. Wages for these employees shall be governed by the Labor Employment, Skill Development, Entrepreneurship Department, notification number so and so, as amended from time to time, with effect from the date of joining the duty assigned to them. Now, my lord, the petitioner's name is reflected at serial number 9. And even though he has been relieved of his service, my lord, he has been continued to be paid the wages, my lord, and these are reflected at page number 110, my lord.
He's receiving his wages?
He's receiving his wages, There were no termination papers have been given to him, my lord.
So
And-
maybe there are going to be two of them,
No, there's only one, my lord. There's only one. There's no dispute
but
about
he's
this.
getting his pay, his wages.
So, my
Till
lord,
when was it
till-
stopped, his
till-
wages?
No, his wages have been paid till the month of September.
September.
So our basic argument, my lord, at this stage is,
Uh-huh.
it appears to us, my lord, no formal termination of his employment has been done. So in that light, my lord, our humble submission is to allow him to continue in his service until some action has been taken against him. Because, my lord, till now he has been stopped from serving. And the respondent number 5 has been appointed in his
But
place.
still the month of September, isn't it? So see in the month of October, now he's still getting his pay, so it's very good. He's getting paid a holiday. That means, isn't it? It's in his advantage
It's in
then.
disadvantage. No,
Because
definitely.
there's no formal termination, isn't it? Then maybe the verbal information that which he received wasn't taken very seriously by the department.
No, because, my lord,
So
let me
if he's
tell
still getting his pay,
let me
what
tell you, Lordship, one
grievance,
thing, my
huh?
lord. Yes. So the factual reality is like this, my lord. Of course, your Lordship is right that from paper it looks, my lord, that he has continued his employment. Rightly so, my lord. Your
Yeah,
Lordship
and
is
no
correct.
formal termination.
Yes,
So
no
is
formal.
they-
So on
are they
paper, my
giving
lord,
him his pay?
now the practical reality is slightly different, my lord. And this is why we have come to this court, my lord. There is only one check gate. And these check gates have been made, my lord, as per the finance department and all of their approvals, my lord. Now,
But do you have the appointment order of the other person?
no, he has not,
Then?
my lord, but in spite of this, they are making him work there. And so, my lord, let them, my
So
lord,
from where is he getting his pay?
the other side, the other person.
The respondent.
So let me tell your lordship, my lord, the new development that has happened on Saturday. On Saturday, the other side, he has approached the police department and he has filed an FIR saying that he has not been paid his salary, and then the salary has been paid to this person wrongly
For which month?
for this month of September.
September, while you are also being paid.
No, so I have been the only person being paid till today. He has not been paid.
Huh.
So because of this reason, my lord, he has approached the police. And he has approached the police saying, my lord, that I have been wrongly paid the
Who
salary.
has approached the police?
The respondent number 5. So now my humble submission, my lord. Of course, your lordship's right, my lord. This is even prima facie, it's very clear that he has continued in his service. My lord, at this stage, if your lordship, instead
Oh,
of
you have apprehensions, but nothing has happened to you. You are getting your paid. The other person is not appointed yet. Maybe he was verbally appointed, and the department cannot take any action in compliance with the verbal appointment. So now your stand is still there. You're getting your monthly pay, your appointment. There's no termination. Just some person comes. So the FIR, if a FIR has been registered, then you file
So, my
this
lord,
thing for quashing the FIR.
my lord, can it be done like this, my lord? At this stage itself, this matter can be disposed of, my lord. And with a simple observation from the court, my lord, saying unless he's properly terminated.
But he is receiving his pay.
I know, my lord, but he's not allowed to continue his service. My lord, that is the problem. My lord, until he has been terminated, my lord, simple order, my lord.
But if you're getting your pay, you are getting a paid holiday.
But my lord, that also is not. That's also not.
You're receiving your pay anyways.
But my lord-
you go for your this thing. Once you are terminated and something happens, you just go and sit somewhere nearby and say, "I'm sitting here. I'm also doing my duty."
My lord, it's just simple protection.
Who has prevented him from performing his duty?
My lord, all the
The
respondents.
private respondent?
All the respondents, my lord.
Where? How?
My lord, your lordship is very right because it's difficult to show in this court, my lord, because of the lack of paper. But my lord, we have mentioned in our pleadings at paragraph number 6. At paragraph number 6, we have
Number
mentioned,
six,
my lord, this
page?
page number 8, my lord.
Yes.
That thereafter, the petitioner began serving as a check gate personnel under the respondent numbers 1 and 4
This
at
is
Byron.
since which year?
This
when
was
was-
since 2013, man.
Oh.
2023, sorry.
Okay, 23.
Yes.
2 years.
However, while the petitioner was faithfully serving as such, he received a phone call from the office of the respondent number 4 in the month of July 2025 that he was relieved of his service as per the instruction of the MLA of the said area and that the respondent number 5 would be appointed in his behalf.
But he's not been appointed.
Now, my lord, my lord, if this
So
court-
what is your prayer portion? Let's see, what have you prayed for here? You're receiving your pay. If for them in the month of October you have not received your pay, then you have some reason. Huh.
So, my lord,
What
we
is
have
your
several.
prayer?
So
What
we
is your
have
prayer
several prayers,
portion?
my lord. First is, if your lordship will come to page number 13, as to why the petitioner should not be reinstated. Now, my lord, let's say he is already reinstated and allowed to continue in his service. So this aspect, my lord, if he is allowed to continue in his service, my lord, if he may be allowed at this stage, with all consequential benefits, and as to why the respondent should not be interfere with his duties in the future. So these two prayers, my lord, which we have made, along with the first, my lord, the second two, if he may be allowed, and if they want to terminate him, my lord, let them do it formally.
They have not terminated him. There's no formal order terminating him. You see, a verbal threat from someone.
It's not a threat, my lord. It would be a threat if he was not allowed to continue in his service. But, my lord, he has been relieved of his service by verbally. And in a place like his, my lord, in Bairabi village, small village, and his salary, my lord, is 12,000. Poor people, my lord. In fact, my lord, let me be straight to your lordship. This is a pro bono matter, my lord. And this kind of people are being suffering. My lord, a simple protection with until there is a formal termination, my lord, will
He
suffice.
should allow to continue his
Yes,
duty,
yes.
maybe.
Yes, my
To
lord. That's-
discharge his duties.
Yes,
Continue, only that.
Yes, that's it.
Yes. Huh.
Yes, Your Lordship, from the pleadings of the learned counsel, Your Lordship, it can be seen that this matter, the matter in issue is between the applicant as well as the respondent number 5. So the state
Respondent
government
number 5
is
is who?
the private respondent whom he claimed that he was filing the FIR.
No, he's saying it's not only the respondent number 5.
No, Your
but the
Lordship, there is no
respondents.
formal termination of his
No
service, only the phone call.
termination.
And in these writ matters, a phone call cannot be challenged.
Hmm.
There is no letter which has to be challenged by the applicant. And there is no
a
formal
verbal thing.
termination, and he received his
I think
salary
it's
till
a bit
September.
premature. You can come again if he's not receiving his salary,
Exactly, yes.
something. He's receiving it now. This is the month of for
He
September.
received
has
his salary on 1st September 2025, that is this month.
So you see in October, if he's not receiving his this thing,
My lord,
he can show the person, the people in charge, that this is I have not received any termination order.
my lord, my simple
Acting on a verbally or over the telephone or what?
over the telephone. my lord.
Verbally he informed, it seems that he was informed on July, but still he received his salary
My
till
lord,
September.
my lord, in a place like Mizoram, my lord,
Oh.
no lunatic, my lord, will come to court unless he's facing this kind of problem. My humble prayer, my lord, is until they have this formal termination, my lord, let him have this small protection, my lord, from the court. And your lordship can always say, my lord, this is premature, and if anything happens, we can come back in the future. But, my lord, this simple thing of protecting him, my lord, until there is a formal termination. That's all, my lord.
Your Lordship, still, if there is no termination at all, what kind of protection he is asking for?
He's not terminated.
He is not terminated,
He's
and
still receiving his pay. But maybe it's premature. We'll say it's premature. However, he may be allowed to, since there's no termination order, he may be allowed to perform his duty. Then we will dispose it of like that. I'll pass the order later.
Deeply obliged, my lord, deeply obliged.
Disposed of. Order will be passed later.
Admission, item 2.
May it please your lordship, I'm appearing on behalf of the state respondents. As per my verbal instructions, the parawise comments have been submitted to the law and judicial department for vetting, your lordship.
Okay, you are not able to come to any settlement. Is it? So now the stage is for you to file your counter.
Yes, your lordship.
Okay. Mr. F. Laleng Liana, learned counsel for the petitioner, is present, along with Ms. Lal Nundui, learned government advocate for the state respondents. Full stop. The learned government advocate has prayed for further time to file the counter affidavit by submitting that the matter has been sent to the Law and Judicial Department for vetting, and the counter affidavit will be filed
Your Lordship, 2 weeks' time.
within 2 weeks. In view of the above, list the matter after 2 weeks.
Much obliged, Your Lordship.
Item 3.
May it please Your Lordship, I'm appearing on behalf of the state respondents 4-5 and also for the ADC Khozol, which is respondent number 6. Your Lordship, in this regard, for respondent number 6, the affidavit in opposition has been prepared and it will be submitted to the court within this week, Your Lordship.
Okay, government is respondents number
4 and 5, Your Lordship. And
4
then
and
the
5.
Kala is...
and 6,
yes,
isn't
Your
it?
Lordship.
So 4 and 5, have you filed a counter?
No, Your Lordship, if 3 weeks' time will be given for that...
4,
the
5
same, Your
and
Lordship.
6?
Yes, Your Lordship.
Yes, what about CGC?
Lordship, similar prayer for respondent number 1.
What's the writ petition about?
My lord, this is a challenge to the order dated 13/8/2021, wherein the assessment was barred against the land of the petitioner. We are owners of a plot of land. It has a quarry in that, a stone quarry.
Okay, no compensation
No
has been
compensation
paid.
has been paid.
And your landed property has been acquired? I
Yes.
mean, has been taken possession of? is
Yes,
it?
my lord.
Then you have to see, isn't it? You just can't go and take possession of someone's land and use it if it's found that he's the rightful owner. Some compensation has to be given.
Your Lordship, it is a stone quarry and...
Stone quarry.
yes, Your Lordship.
So you're saying you're not liable because it's goods from the ground, is it?
Yes, Your Lordship.
Okay, we'll see whether for quarry. Then you'll have to see, yes. Heard Mr. Instead of heard, Mr. Lal Rokunga Pautu, learned counsel for the petitioner, is present, along with Ms. Lal Nunglui, learned government advocate for state respondents number 4, 5, and 6.
6 is Kala, Your Lordship.
4 and 5, and also for respondent number 6, Ms. Baby so-and-so, appearing on behalf of Ms. Zairam Sampui, learned CGC, for respondent number
1.
1 and Mr. Samuel Malaysia Tatsanpe, learned standing counsel for respondents number 2 and 3. The learned counsels for the respondents have prayed for further time to file their counter affidavits by submitting that the counter affidavits are under preparation. In view of the above, list the matter after 3 weeks.
Allowed 2 and 3, we've already submitted.
Okay, then you say the learned counsels for the learned government advocate, okay, and learned CGC have prayed for further time to file their counter affidavits by submitting that the counter affidavits are under preparation. Okay. It is also submitted that by the standing counsel for respondents number 2 and 3 that they have already filed their counter affidavit. In view of the above, just after 3 weeks.
Obliged.
Item 4.
Your Lordship, this regular first appeal is filed against the impugned judgment or order and decree, wherein the civil suit filed by the present appellants was partly decreed, my lord. The appellant number 1 is the first wife of the deceased J. Malsoma, and the appellants 2 to 4 are the daughter and sons. And we
Of the
claimed for,
second wife.
the respondent is the second wife, my lord. Three appellants, 3 and 3, 2 to 4 are the children of the deceased with the first wife.
First wife.
Yes, and the appellant number 1 is the first wife.
So the children are also filing the case against their mother,
Against
biological
the,
mother,
against the second wife, my lord.
the second wife.
Yes.
Okay. So the appellant is the second wife.
Appellant is the first, appellant number
wife.
1 is the first wife.
Appellant
And-
number 1.
Yes, number
How
1.
many appellants are there?
Appellants, 4 appellants are there. And 2,
So only
3,
one appellant has filed the appeal.
no, my lord. The appellant, the 4 appellants are filing the appeal. 4 appellants. Number 1 is the first wife.
Okay, and 3 others. Simply
3 others are the children with the first wife.
So appellants are the first wife and children. Is it?
Yes, first wife
the-
and children. And the respondent
respondent
is the second wife.
second wife.
Yes. We had claimed for
What is
declaring
the property
properties
in
are
dispute?
landed, immovable and movable properties
Huge amount.
situated at Sumsui village.
So what will be the value of the property? I
Value of
mean,
the
no, I'm
property-
just wondering,
Yes.
is there possibility of them coming to some amicable settlement or not?
It may,
What-
there
what
may
is-
be a
what
chance,
are
my
they
lord.
finding? The building.
Yes.
Okay, I'm reading from this
I may-
page L,
I may refer to page 25.
25. What are the
25.
properties
These are the
involved?
properties. This is the
So for
plaint.
how many years was he married to his second wife?
Second wife, Lord,
Any idea?
it
Who is
was,
representing? Okay, this is the first time it's coming up. Then
Yes.
we'll have to issue notice first.
Yes, and
anyways,
thereafter
isn't it?
there may
Then
be a
we'll
chance.
see, huh? Because 25, here properties, Assam type building.
Yes,
RCC
RCC building.
Royal Enfield bike,
Bolero,
Mahindra Bolero.
sawmill, and
huh.
2
Huh,
other
so
plots.
there's a possibility of
Yes,
them,
there
but
may be
let's issue notice first.
Yes,
huh.
my lord.
Ahad Mr. Bilal Ramega, Learned Counsel for the appellant, who has filed the instant appeal under section 96 CPC, read with section 17 within brackets 2, close bracket, then again within brackets small b of the Mizoram Civil Courts Act, 2005, against the judgment and order dated 18/06/2025 passed by the learned civil judge within brackets senior division close bracket dash Roman 3 Aizawl district in civil suit number 44 of 2021, wherein the claim of the appellants to inherit the properties of her deceased husband, Sri J. Malsoma, was rejected, and the civil suit was decreed in favor of the respondents. Full stop. Yes, issue notice to the respondents through registered post. It's only one respondent, isn't it?
Yes, my lord. Sole
Issue
respondent.
notice to the sole respondent through registered post with AD within 3 working days, returnable by 3 weeks. Just after 3 weeks.
Much obliged.
Orders, item 5.
My lord, this matter has been referred before the mediation. However, my lord, settlement could not be made.
Oh, why? MACT usually
Yes,
it's the amount.
My lord, apart from the amount, we have raised certain points like negligence of the driver as well as the
Okay,
license of-
who appeared for the mediation? Did the parties appear or you appeared
Parties.
on their behalf? The parties were there?
Parties, yes.
Okay. Yes, then, what is the stage where we left out? Respondents number 1 to 6.
1 to 6.
So
is
all the parties are represented?
Yes.
How many respondents? 1 to 6.
Respondents 1 to 9 in the make appeal, my lord.
Then,
1 to 6 is the claimant, my lord, before
okay,
the
then 7 to 9 will have
My Lord,
to.
I'm for respondent number 1 to 6, my Lord.
7 and 8 are the first owner and the second owner, my lord.
So in the last order, previous order, dated 24/07,
Yes, my lord.
2025, it was seen that notice upon respondent number 7 is yet to be complete.
We have taken
No,
steps.
7, 8, and 9.
Yes, my lord.
So you're saying that the compensation has to be paid by respondent number 7 is the owner of the
7
vehicle?
and 8 is the first and second owner, my lord.
So they have to be present.
Yes, my
So you take fresh steps.
Yes, my lord. My lord,
7 is
what about
correct
the
address you have to
return of
find.
notice, my lord?
Pardon?
What about the return of notice before, for the 7 and
Not
8?
returned yet.
Not return.
So we have to wait. They were not there for mediation, is it? So instead of waiting, you issue fresh.
Anyway, my lord,
uh,
7 and 8
through
are not,
Dusty. What?
they are not the aggrieved party, my lord. Since the insurance was valid, so before the tribunal also, they have, the claimant have challenged, and my lord, if it is necessary, then if
So
the,
you're the insurance company, isn't
Yes,
it?
my lord.
You're saying you don't have to pay. It's the owner and the driver, the owners who have to pay. Then they have to come.
yes, my lord.
You have to complete the notice,
Yes,
isn't it? So you will
We will try by way
through-
of Dusty, my lord.
through the, this thing. You try to serve notice through Dusty, maybe.
Yes, my lord.
Heard, Mr. Yes,
H. Zodin Saha.
H. Zodin Sanga, Learned Counsel for H. Zodin Sanga, Learned Counsel for the appellant, along with Mr. Benjamin Lalkamwana, Learned Counsel for respondents number 1 to 6. The learned counsels submitted that the parties were not able to come to any settlement through mediation. In view of the above, this court find it. In view of the above, this court finds that notice upon respondents number 7, 8, and 9 is not complete till date. As prayed for by the learned counsel for the appellant, notice may be served to the respondents number 7, 8, and 9 through Dusty mode, and affidavit to that effect is to be duly filed after 3 weeks.
Yes, my lord.
3 weeks.
After vacation.
After 3 weeks, just after 3 weeks.
Much obliged.
Item 6.
May it please your lordship. My lord, we have filed objection for the delay petition, my lord. If your lordship,
Written objection filed.
yes, yes, my lord.
When did you file?
On the, if I'm not mistaken, or 22nd or 23rd of August. 22nd.
Yes, already filed. It's here.
Yes. If your lordship permits, my lord, it may
22nd.
be, hearing may be conducted after vacation, my lord. Hearing on the delay application. my lord.
You're not prepared today.
Yes,
Moreover, my lord, I'm yet to receive a copy of the objection, my lord. I've not yet received the same.
Yes, so you have to give a copy.
yes, my lord.
Mr. Samuel Vandershiata Changte, learned counsel for the applicant slash appellant, is present along with Mr. Lalbiaknunga Namte, learned counsel for the opposite party. So the learned counsel for the opposite party submits that he has filed his written objection. However, the learned counsel for the applicant submits that he has not received a copy. In view of the above, copy of the written objection to be duly furnished to the learned counsel for the applicant. List the matter, then list the matter after
After vacation.
The vacations, okay, ensuing vacation.
My
Item
lord,
7.
Similar prayer with regard to item 7 and 8, my lord. All
What, you have filed, not received?
Yes.
Okay, then same order.
We'll serve them today itself, my lord.
No, same order for 7 and 8.
Deeply obliged, my lord.
7 and 8, same. Same order.
Item 9.
May it please, Your Lordship. As per the last court order dated 15/9, we have received instruction from our client, and if this matter may be referred to mediation. my lord.
You are willing? Okay. Mr.
Samuel Lompuya.
Samuel Lompuya, learned counsel for the applicant slash appellant is present along with Mr. Lomo Maralte, learned counsel for the opposite party slash respondents. The learned counsels submit that both the parties are willing to have their matter referred to mediation. In view of the above, matter is to be referred to mediation, registry to do the needful. Yes.
That's right. Item 10.
May I please, Your Lordship? The matter is listed for the first time. Eh, It is a regular first appeal, and due to bona fide reason, we have delayed in 90 days, so a separate application for condonation application is filed.
Okay, will issue notice.
Yes, Lordship.
Heard, Mr.
Ke Kam Thian Manga.
K. Kam Thiamanga, learned counsel for the applicant who has filed the instant application under Section 5 of the Limitation Act, read with Order 41, Rule 3, Rule 3 dash capital A, CPC, for condonation of a delay of 90 days in filing an appeal against the it's judgment, isn't it? Judgment and order.
Judgment and order. Yes.
Dated 19/03/2025, passed by the learned civil judge, within brackets, senior division, close bracket, dash Roman 6, comma, Izol in damage suit number 3/2015. Full stop. Issue notice to the opposite parties through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Obliged, Lordship.
Hearing item 1.
Okay, we are going to continue. I think we had filed, called for the record contempt. It's here. Who is the counsel? CGC.
CGC is in another court.
Okay, we can continue. I think she's made her submissions.
Yes, it's
We can proceed. Okay, now in the last court date, we had mentioned that contempt case number so and so should be tagged
Yes.
along. Because in the WPC, it was mentioned that in the presence of both the parties. But, and then verification was done. Therefore, contempt petition was closed. If contempt petition was closed, it's presumed that the verification must have been done in the presence of both the parties. If not, You should have said that it was not done in our presence, so contempt cannot be closed. So anyway, let's see the order. So the learned counsel for the petitioner was Victor L. Ralte then. He submits that the respondent, Mr. Victor L. Ralte, counsel for the petitioner, submits that the respondent has complied with the order dated 01/05/2015 passed in WPC 48 of 2025. Therefore, contempt is closed. Then you cannot take the stand again that we were not present, because WPC says that in the presence of both the parties, and parties also should be given a chance to file their objection or whatever, something in the writ petition. So what do we do?
Not it. I was at page 4 of my synopsis. I have taken the Lordship through the order passed in connection with the connected civil suit, where the Learned Trial Court was deciding issue number 14. And in that, we had taken the stand that the order that was passed against the plaintiff and the defendant. In fact, plaintiff and defendant were having dealings in respect of the land, which was under permit number 191 of 1974.
You see,
Now-
but see, you're saying that the main matter or the main crux of the case is the disputed order, that is 11th August 2015.
2411.
2411 concerning the demarcation or the verification made concerning the land, isn't it? Where's
Yes.
that order?
Yes.
So, but if you say that you accept this, then you have to go by that order only.
No, that has been challenged. That has been challenged, and that has been set aside. That order
Where,
has been
where?
challenged and set aside by the Learned Trial Court. 24/11,
That's what, no,
2015.
there's a judgment of the High Court. Okay. No, not the judgment of the High Court in WPC. Okay,
Yes.
let's try in WPC, the High Court has ordered that the respondent authorities have to verify,
Yes.
okay, the land, and as per the verification report, which is the, you're saying, the verification report dated, which is the date in the contempt?
The finding that has been arrived at
Huh,
by the authorities of the Revenue Department,
that's the main
was
crux of the matter,
17/11.
isn't it?
24/11,
24/11.
2015.
So now in the contempt, it says that it has been complied with.
Complied
The
with
order.
means whatever order that needs to be passed was passed. It's not that we accept the order that was passed in connection with.
But in that order, in the WPC, it says that it should be done in the presence of both the parties.
Yes,
You were present then? Because I'm
It
just
was
asking
decided.
that question because in one of your points, you had mentioned that the verification was done without your presence. That was one of your points you mentioned. That's why it comes to
Lordship,
the...
Lordship, that is a matter which is baffling a Lordship. But the thing is, at this stage, we can just pass on.
Okay.
And we can just
Go ahead,
have a
huh.
look at it as and when required.
Huh.
So, on the basis of the findings made by the Learned Trial Court in connection with the earlier earlier suit, before it was recast, it was amended, in which the present appellants were impleaded as respondent number 6 and 7. Now, the decree was passed, and the decree can be seen at page 277. The 277.
That is the final decree which you
Yes.
are unhappy with.
The decree, yes.
Appellants are
Dated
unhappy
5/4/2019.
Anyway,
It's
let's
a
see.
very short decree, Your Lordship. May I read?
1 minute. 277.
Yes.
Okay.
Here it says, in the light of the above findings, the instant suit is decreed. The order dated 24/11/2015 is declared illegal, null and void, and the cancellation of permit number 191 of 1974, void the said order 24/11/2015, are hereby set aside and quashed, and permit number 191 of 1974 reissued on 17/11/2003 with the approval of the government is hereby revived. However, the area of land already settled in favor of the pro forma defendants, number 4 and 5, shall be deducted from the area of 29.48 bigas, initially covered by permit number 191 of 1974. Therefore, defendant number 2 and 3 are directed to make necessary corrections with regard to permit number 191 1974 and to demarcate the land covered by the said permit located at Zemabo, Aizol, and to bifurcate them into 2 equal halves in favor of the plaintiff number 1 and defendant number 1. Therefore, the plaintiff number 1 shall be issued a respective land pass in her name for the side facing towards Aizol. Defendant number 2 and 3 are further directed to comply with this order within a period of 60 days from the date of this judgment and order. In fact, Your Lordship, the defendants number 2 and 3, who are the state authorities, they have already complied with the direction, the decree passed by the learned trial court, and they have bifurcated the land in question in 2 halves, 2 equal halves, and they were issued respective land passes to both the defendant, to the plaintiff and the defendant number 1. Thereafter, Lordship, may I take Lordship to point L at page 4 of my synopsis.
Page 4.
Page 4 of my synopsis, L.
Page 4. You come to the paper book, isn't it?
I have come out from the paper book. I have referred to the synopsis which I have prepared as a guide also.
Chart for hearing. Okay, synopsis for arguments. Okay, this one. Page 4.
Wherein I have stated that the chief engineer, BRTF Project Puspa, having been furnished a copy of the judgment and order dated 5/4/2019, along with the decree, white letter dated 7/2/2022, Exhibit D24 at page 581. The matter was challenged by the appellants by filing RFA number 16 of 2020, Exhibit 27, P27. And the same was disposed of by the Honorable High Court, white order dated 16/9/2021. Lordship,
16/9.
16/9.
Where's that order?
16/9/2021. Order is at page 279. And it can also be seen at page 609 to 612.
279.
Almost everything has been made in duplicate. 279, the first book.
Yes.
May I read the Lordship? The at Mr. So-and-so. And coming to the operative portion, at para 12, as a matter has been pending along, no, before that,
Yes.
accordingly, the parties shall appear before the learned trial court on 24/9/2021. The learned trial court shall implead the appellants as defendants number 6 and 7 in the civil suit and allow them to submit the written statement within a specific time period. Appellants may also be allowed to cross-examine the witnesses if the learned trial court decides to retain or rely upon the evidence of the witnesses already recorded by the learned court. As the matter has been pending a long time and issue at hand, with regard to the appellant's stand, being of a very specific nature, which may require a verification report to be made by the Land Revenue and Settlement Department, learned trial court shall make an endeavor to dispose of the civil suit as early as possible and preferably within a period of 1 year. Consequently, the impugned judgment order dated 5/4/2019, passed by the learned trial court in civil suit number 59 of 2016, is hereby set aside. So the order passed earlier in the first round in connection with civil suit number 59 of 2016 has been set aside, and the matter has been remanded back to the trial court. And thereafter, a recast plaint was prepared by the plaintiff by impleading the respondents, the present appellants as defendants number 6 and 7, as can be seen in the pages 283 to 284.
So the appellant had objected to the recast plaint,
Yes.
isn't it?
Yes.
Ah,
On the ground that without taking permission of the
oh,
trial court, the amendment was made. And in this connection, may I take a lordship to the provision of CPC,
yes.
Order 1, Rule 10, Order 1, Rule 10, subclause 2. May I read the lordship?
Yes.
Court may strike out or add parties. The court may, at this stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all questions involved in the suit be added. So, as directed by the Honorable Court, parties have been added. And
So the appellant was also added,
yes,
isn't it?
yes,
Oh.
Lordship.
So on adding the appellant, you have filed a recast plaint, is it?
Right, yes. And the suit proceeded on in the presence of the appellants. All other parties remained the same. And during the course of the subsequent proceeding, the evidence of the plaintiff was again recorded because when parties are added and the prayer was also modified, the relief sought being against the respondent number 6 and 7, defendants number 6 and 7, which was not there earlier, needs to be properly explained. And for that, the evidence of the plaintiff was taken afresh. While the state defendants prefer not to adduce any additional evidence other than what was already recorded during the earlier proceeding, while defendant number 1 had adduced further evidence by producing his wife, Srimati Lalkumtiri. Defendants number 6 and 7 had adduced the evidence by producing the witnesses such as Salming Thanga and Narendra Kumar Nisant. Lordship, the statements of those defendants, number 6 and 7, the witnesses are there at page 798.
$798, huh?
790. Except for the names and the identities of those witnesses, such as Salming Thanga, who was present at the time working as Joint Director Administration, Nodal Officer Legal, Headquarters CPW, P. Puspak, and project under Project Puspak, Mizoram do hereby. And so far as the other witness of the defendant number 6 and 7,
826. Is it?
Yes, 826. Except for their names and the post held by them, all statements of those two witnesses are the same. And it may not be necessary to read both the evidence. At least may take lordship to the cross-examination of Chalming Thanga, which is at page 817, starting from 816. At page 817, lordship, paragraph 5. It is stated, it is a fact that though permit number 190 of 1974 and permit number 191 of 1974 was converted into P-Pata number 4 and 1 of 1977 respectively by DC, Aizawl, since both the land P-Patas are within Aizawl town area. They were reverted back to permit number 190 of 1974 and 191 of 1974 in 1997. Para 6. It is a fact that award number 9 of 1989 was passed for the purpose of acquisition of land for the office complex of Project Puspak, BRTF. 7. It is a fact that permit number 191 of 1974 was not included in the award number 9 of 1989. However, permit number 190 of 1974 was included in the said award at serial number 62 and serial number 49 in the name of claimants, with a remark saying permit number 190 of 1974 as no definite claim. This can be seen from the exhibits, Your Lordship, in connection with the word number 9 of 1989. So it is here been clearly admitted that permit number 191 of 1974 was not included in a word number 9 of 1989. And para 8, it is also a fact that as there was no definite claim with regard to permit number 190 of 1974, no amount of compensation was paid to the landowner, namely Dian Tudaya, as no amount of compensation is paid to the said landowner, permit number 190 of 1974 was released to his son, namely Tanzawa, on 7/12/2001. Para 9, it is a fact that the area of land under permit number 191 of 1974 was enlarged or enhanced from 2 bigas to 29.48 bigas by the Revenue Department on the basis of the joint verification report dated 24/3/2003 on the basis of the documents. 10. It is a fact that permit number 191 of 1974 was not included in the list of acquired lands for the purpose of office complex for Project Puspa. 11. It is also a fact that permit number 191 of 74 was not acquired by BRTA for defendant number 6 and 7 at any point of time. 12. It is a fact that though airship certificate of Tanzawa does not specifically mention permit number 191 of 1974, the perusal of airship certificate shows the properties as all properties left behind by the deceased. 13.
So
is
the
a-
present case is concerning 191.
Yes,
isn't it?
191.
Oh, okay.
It's a fact that airship certificate was issued to Tanzawa due to death of his father, Dian Tudaya. It's a fact that defendant 6 and 7 admitted to the claim of the plaintiff to the extent of 2 bigas and not 29.48 bigas as per permit number 191 of 1974. This has been the stand of the defendants number 6 and 7. So they said that the area of the said permit 191 of 1974 is not 29.48, it is 2 bigas. And para 15, it's a fact that the area of land acquired for office complex for Project Puspa from Bielzava, White LSC number 103/85 is having an area of 16,765 square feet, as shown in award number 9 of 1989. It's a fact that I do not know the boundary description of LSC number 103 of 1985 belonging to Bielzava. It is a fact that I do not know whether the boundary description of permit number 191 of 74 and LSC number 103 of 1985 belonging to Bielzava are the same or similar or not. 18. I do not know whether permit 191 of 74 having an area of 29.48 bigas issued by the Revenue Department was challenged before the competent authority by defendants number 6 and 7. In fact, may I pause here a little bit, Your Lordship? The fact that there was a finding of the Revenue Department that there was miscalculation of the area, and it was simply presumed that the area of permit number 191 of 1974 would be 2 bigas. So without making any proper demarcation, it was taken as such. And now, when it was properly demarcated, it was found that the area covered by the boundary description of permit number 191 of 74 came to 29.48 bigas. And that finding was never challenged. It was never challenged by the appellants. it was never challenged by the defendants number 6 and 7 by filing a suit. And even in the said civil suit, when they were impleaded as a party, they did not make any counterclaim to that effect also.
So in the report, 24th 11, this was the finding or no?
24/11 of 2015. This is the finding of, this the subsequent finding. This is the previous finding. We're talking about the earlier finding. In 2004, the finding was already recorded.
I'm getting a bit confused.
Yes,
Anyways.
Your Lordship.
Anyways, there was this finding. The verification done where the contempt was closed. Okay, the contempt was closed, and that verification that was done. Okay, was it the same finding here?
Yes, they have come to the same
29.48.
finding.
Same.
Yes.
Okay, yes. And this was never challenged. 29.48 because instead of 2.
It was never challenged. And para 19 of the cross-examination, I agree to the suggestion that the Revenue Department, that is defendants number 2 and 3, is a competent authority in respect of issuance of land passes such as LSC, permit, P-Pata, etc. within the state of Mizoram. 20. It is a fact that the defendant number 2 forward letter dated 17/2/2004 to defendants number 6 and 7, claiming for rental charges for occupation of private lands at Zemubok Aizol. However, the same was not accepted by defendants number 6 and 7. They said that they did not accept to that, but they did not hesitate. Here, may I take a lordship to Exhibit D18. Exhibit D18.
Page?
It's at page. Exhibit D18 is at page 538 to 541. This is a letter sent by the Undersecretary, Government of Mizoram, Revenue Department, addressed to the Chief Engineer, Project Puspa. Page 538. May I read the lordship?
Yes.
This is in regard to payment of rental charges for occupation of private land at Zemubo, amounting to rupees 5,64,03,449. With reference to the above subject, I am directed to enclose herewith assessment of rental charges for occupation of land belonging to Lian Tudaya, late, located within the acquired area of the Puspak at Zemubo, amounting to rupees so-and-so, only for necessary payment. While considering the matter, the following may be taken into account. Number 1, Lian Tudaya late was allotted garden permit number 682 of 1963 by the RS12 District Council. 2. This permit was bifurcated into permit number 190/74 and 191/74. These two permits were converted into P Pata number 4 and 1 of 1977, respectively by DCI zone. However, since the land covered by these two P Patas is within Aizol town area, they were reverted back to permit number 190, 74, and 191 of 74 in 1997. The area of land covered by permit number 190 of 74 lies within Aizawl city area by the side of Dungley Road. This area was released to the owner on 7/12/2001. Next page, Your Lordship. The area of land under permit number 19174 was entered as 2 bighas. However, representatives of Revenue Department and the project Puspak conducted joint spot verification to ascertain the exact area of the land on 24/3/2003 and found that the area covered by permit number 19174 is 29.48 bighas. Joint spot verification report at Annexure B. Hence, the government of Mizoram approved that the area covered by permit number 19174 is 29.48 bighas, and that permit number 19174 was corrected and reissued accordingly. Pu F. Bielzawa, who has a plot of land adjacent to Liantudayas, had already received compensation for his land covered by LSC number 103 of 1985. The entire land covered by permit number 19174 is shown as Block 3 in the Puspak acquired land map. The area under permit number 19174 is free from encumbrances, hence there is no dispute in terms of ownership. Since Liantudaya died on 20/2/1986, his son H. Tanzawa Saitual is a legal heir, as per heirship certificate enclosed. As regards the rate and methodology adopted for calculation of rents, the following may be noted. The value of land is fixed at ₹5 per square feet per annum, and as this was early adopted by the Board of Officers constituted in connection with payment of rental charges for private land occupied by the Army in Mizoram. Further, both the Assam Urban Areas Rent Control Act and Mizoram Urban Areas Rent Control Act were made applicable to by the State Board of Officers for assessment of rentals. Hence, for calculation of rentals now, these two acts are applied. Minutes of Boards of Officers of Annexure E. It may further be mentioned that prevailing land value per square feet as fixed by the collector Aizawl for certain area in Aizawl city is ₹200 to ₹500 per square feet. It is therefore requested that immediate action may be taken for payment of rentals amounting to ₹5,64,000 and 3,049 in favor of Tanzawa, son of Liantudaya. This was a letter which is at Exhibit B 18. Lordship, may I state that this letter was duly received by the Chief Engineer, Project Puspak, and it was not acted upon. It was way back in the year 2004, and the assessment was prior to that, and this was never challenged also. The fact that they are to pay the rental compensation of this amount was never challenged.
So this covers the land within 191.
191. This is what has been stated here under para 20 of the cross-examination. Let me repeat. It is a fact that defendant number 2 forwarded a letter dated 17/2/2004 to the defendants number 6 and 7, claiming for rental charges for occupation of private lands at Zemub of Aizawl. However, the same was not accepted by the defendant number 6 and 7. If that was not accepted, it was the obligation on the part of the authorities of the appellants to agitate before any appropriate forum. But they simply kept silent. They waited for another order. And para 21, it's a fact that I do not know whether letter dated 17/2/2004 was challenged before the competent court. by the defendants number 6 and 7. He said he did not know, but the fact remains that no challenge was made. If I take lordship to page 538, yes, the same thing, to 541, the contents of the letter has been can clearly be seen. And para 22, I deny to the session that the letter dated 17/2/2004 clearly shows that the land under permit number 191 of 74 was accepted as being under possession of defendants number 6 and 7 by the Revenue Department. I deny that he has denied, but the fact remains that the said land with an area of 29.48 bigas was under the occupation of defendants number 6 and 7.
This is a denial of the
Yes.
sedition, isn't it? No.
And para 23, it's a fact that the reason for filing RFA number 16 of 2020 by defendants number 6 and 7 was based upon the advice of the state defendants. So they were advised. They did not take up the matter of their own. It is only on the basis of an advice of the state government that if you are aggrieved, you may file an appeal. If you are not aggrieved, you may not file an appeal against the order passed in the said declaratory suit, civil suit. Para 24, it's a fact that we have no grievances against the order portion in page 28 of the judgment and order, dated 5/4/2019, passed by Senior Civil Judge Aizol, Judicial District Aizol in civil suit. Lordship, to see
What
the-
is that?
the meaning of what they have,
Page 28
Page-
of the judgment
page
and order.
28 of the judgment.
What does it say? We are not agreed with that. Where is the judgment?
The first judgment at page 279 to 282.
That is the first book. 279.
No. Lordship, is the order of noting I report. 247 to 270. 247.
247.
247. Yes. What they have stated here, it's page 28 of the judgment. The order portion.
No, I don't think you understand. 247.
Yes, starting from page 274.
74. Two 74 is something very different. When you read the paragraph, what
274, it
does
is,
it say?
in view of what has been stated above, it is hereby decided that order dated 24/11/2015 is illegal, null and void, and the cancellation of permit number 191 of 74 by the said order dated 24/11/2015 are hereby set aside and quashed, and permit number 19174 reissued on 17/11/2003 with the approval of the government is hereby revived. However, the area of land already settled in favor of the pro forma defendants 4 and 5 shall be deducted from the area of 29.48 bigas initially covered by council be issued a respective land pass in her name for site facing towards ISO. Defendant number 2 and 3 are further directed to comply with this order within a period of 60 days from date of the judgment order. So this is the order portion which is being referred to here at para 24. To that, the witness had clearly stated that they had no grievances against the order portion in page 28 of the judgment and order dated 5/4/2019.
So 24/11/2015 is illegal. They agree with that.
Yes, they agree with that. When they have no grievances, it is only implication. But at the same time, he had denied the suggestion at para 25. I deny to the suggestion that BRTF is in illegal occupation of permit number 191 of 74. However, 26, he admitted, it is a fact that the BRTF does not have any land pass for Block 3 of the office complex for Project Push Park, issued by Revenue Department, Government of Mizoram. And re-examination was conducted. That, he said, with reference to my cross-examination para 9, I stated that I was not present at the time of decision made by Revenue Department, and I do not know the reason why Revenue Department enhanced the area of permit number 191 of 1974 from 2 bigas to 29.48 bigas. So he was not personally present, but the BRTF is not a necessary party for that. And cross-examination by counsel for defendant number 1. Counsel for the defendant number 1 adopted cross-examination of plaintiff's counsel. So no further cross-examination was conducted by the defendant number 1, who is the respondent number 2 here. And cross-examination by counsel for defendant number 2 and 3. Counsel for defendants number 2 and 3 declined cross-examination. So the subsequent pages are repetition of what is already there. It is very strange, Your Lordship, that exactly the same thing has been recorded under during the cross-examination of the second defendant witness.
What about in chief? Exactly the same?
In chief also same. Reference only in name. Same questions were asked. Same answers.
Question, same reply.
Yes. And even in the cross-examination, however, the difference is that it has been typed out. Everything said. Even re-examination, even cross-examination by counsel for defendant number 1, by defendant number 2 and 3. Everything said. So he has put his signature in acceptance to all that was recorded on 22/4/2022. So that was how the proceeding was pursued by the defendants number 6 and 7. And may I take Lordship to page 734 and 738. 734 to 738. This is the spot verification. "734 is a letter regarding duty report submitted by the surveyor, Kela Chanpuya. It was in vernacular. And the translation is at page 736. It's only 2 pages. May I read the Lordship?
Yes.
As mentioned in the above order, memo number 1, I have performed spot verification in demarcated permit number 19174, and on this day, Mr. Bielzawa was not present, and the below mentioned details are my findings. Mr. Bielzawa is the one to whom some portion of the land has been sold by the father of defendant number 1, that is Tanzava. Bielzawa was not present, and the below mentioned details are my findings. The owner of this land and advocate, Mr. Larshiet Puya, were questioned, and it's observed that permit number 191 of 74 was sliced out from Mr. Lian Tudaya's permit number 682 of 1963. Permit number 682 of 63 was split into permit number 190 of 74 and 191 of 74, respectively, and they are located at Old Aizol Lunglei Road, separated by the passage to the present Falkland area. Permit number 19174 has been sliced out into LSC number 103 of 1985, owned by Mr. Bielzawa, and LSC number 1805 of 2006, owned by Mr. Dila Rintuama. Entire area of this LSC has been carefully measured out today. As permit number 19174 was issued many years ago, the structure of the land area has been carefully measured out, and at present it is ascertained that the land area is 20.2 bigas in area, not 29.48 as per the earlier findings. It appears that permit number 191 of 74 is the area utilized by BRTF as Block 3, and the regions are mentioned below. From BRTF map, it appears that permit number 191 of 1974 was acquired by them from the government, and on their west border, permit number 190 of 74 exists. LLC number 103 of 1985, which was previously owned by Mr. F. Bielzawa, but later acquired by BRTF, is located towards Nzemabok main junction. This clearly indicates that permit number 191 of 1974 exists in between permit number 191 of 1974 and LSC number 103 of 1985. As permit here, there's a mistake. The second 191 is, it should be 190.
Which one?
The last sentence of under A. This clearly indicates that permit number 191 of 1974 exists
Okay,
in between
190.
permit number 190 and LSC number 102 of 1985. As permit number 682 of 1963 is a permit from which permit number 191 of 74 and permit 190 of 74 were born, it is apparent that they would be located next to each other. While permit number 19174 was measured out, Mr. R. Malsom Dongzwala, Senior Civil Judge Aizol, Mrs. Said Hangpui Sailo, Advocate, Mr. Zoram Sana, Mr. C. Lalbunga, Tanzava's representative, Advocate Lalfiat Puya, and representatives of Border Road Organization were all present. They have signed their respective names on the attendance sheet. Nobody had an issue back then, and no objection was raised. I have thus submitted my duty report for further necessary action. So the attendance sheet is also submitted. And this spot verification was as per direction made by the Honorable High Court, 12, remanding the matter back to the trial court. Uh, on appreciation of evidence of both parties, the learned trial court had come to its final conclusion, findings, as per N, at page 5.
Now you're coming back to your synopsis.
Yes, to synopsis. Consequently, the learned trial court had passed the judgment and order dated 17/5/2023, decreeing the suit in favor of the plaintiff and defendant number 1. Number 1, by declaring the order dated 24/11/2015 passed by defendant number 2 as illegal, null and void, and upholding the validity and restoring permit number 191 of 1974, reissued on 17/11/2003 with the approval of the government. 2, bifurcating the entire land covered by permit number 191 of 74 with an area of 20.2 bigas as per spot verification in favor of the plaintiff and defendant number 1 in equal halves, with a direction to defendants number 2 and 3 to bifurcate the suit land in the names of the plaintiff and defendant number 1. 3, defendants number 6 and 7 are directed to hand over vacant and peaceful possession of the said land to the plaintiff within a period of 3 months or to proceed for acquisition of the same within a further period of 3 months. 4, defendants number 6 and 7 are directed to deposit rental compensation amounting to rupees 8 crore 70 lakh an oath for the period from 1/6/1963 to 31/12/2008, as already assessed by the state government within a period of 3 months, and to make further assessment of rental compensation to be made by the defendants number 2 and 3 for the period from 1/1/2009 till date or till the land is acquired, and the same is to be deposited within a period of 90 days after making of the assessment. Lordship, the judgment can be seen at page 845. This is a judgment and order dated 17/5/2023 till 9/04.
This is the impugned judgment.
This is the impugned judgment.
The judgment, the
902.
reasoning, nothing else was discussed, isn't it? So 9 till 904.
904, 902, 903, 904. This is the operative portion. May I take a lordship to 902, page 902?
Yes.
Para 44. In view of the decision made by this court in all the issues, suit is decreed and declared that the order dated 24/11/2015 passed by defendant number 2 is illegal, null and void, and the same is set aside and quashed. Permit number 191 of 1974 reissued on 17/11/2003 with the approval of the government is hereby restored. However, the area of land shall be corrected as 20.2 bigas as per spot verification instead of 29.48 bigas. Therefore, defendant number 2 and 3 are directed to make necessary correction with regard to permit number 191 of 74 located at Zemubor, Aizol, and to bifurcate them into 2 equal portions in favor of the plaintiff number 1 and defendant number 1. Thereafter, the plaintiff shall be issued LSC for her share of land form permit number 191 of 1974, the site facing towards Aizol. Defendant number 2 and 3 are further directed to comply with this order within a period of 90 days from date of this judgment and order. It is needless to observe that defendant number 1 shall get the remaining land of permit number 191 of 1974 after the same is bifurcated as indicated above for the site facing towards Zemubor. Defendants number 6 and 7 are also directed to hand over vacant and peaceful possession of the said land to the plaintiff after the same is divided as indicated above by defendants number 2 and 3. Within a further period of 3 months or acquired the same as per law within a further period of 3 months. Further, defendants 6 and 7 are directed to deposit rental compensation amounting to so and so for a period from 1663 to 31/12/2008 as already assessed by the state government within a period of 3 months from the date of this judgment in order to this court for onward disbursement to the rightful owners for the period from 1/1/2009 to onwards till date or till land is acquired. Defendants number 2 and 3 shall make necessary assessment of rental compensation within the same period of 3 months, and the same shall be deposited to this court within a period of 90 days after the assessment is made for onward payment to the rightful owners in order as to cost. So, Lordship, it is very
So here they're
clearly
saying the whole land or a portion of the land.
plaintiff,
45.
as a plaintiff, 50% of the land has been allotted to me by the decree of this honorable, by the trial court. And the remaining 50% is given to the defendant number 1, who is the respondent number 2. Though initially a claim was made for the whole land, but because of the understanding reached between the parties.
But what about the portion acquired by the appellants? One portion, according to you,
Yes,
one portion,
that
the
is-
LSC,
yes. That has been deducted. After deduction of the portion that has been bought by Mr. Bielzava, which has been acquired. And the land also allotted in favor of the pro forma respondent, pro forma defendant, Mr. Rintluonga, those are not part of this 20
point something bigas.
0.2 bigas. So those two portions are excluded in the calculation at the time of spot verification and redemarcation of the area. So the presence was not much called for because there was no dispute so far as the lands are concerned, and since the lands were already acquired.
Because that LSC is 2 bigas, I think.
Yes, it is more or less 2 bigas.
Anyways,
Lordship, may I take a Lordship to point O? The defendants number 2 and 3, having accepted the judgment and decree of the Landed Trial Court, dated 17/5/2023, as stated above, have not filed an appeal against the said judgment and decree. Consequently, the state government, that is respondents number 3 and 4, cannot be expected to play any pivotal role They are not expected to play any pivotal role in connection with the instant appeal, that is RFA 53 of 2023. And they're supposed to be the silent spectator of the fight between the appellant on the one side and the respondent number 1 and 2 on the other side. In other words, the question as regards the validity of permit number 191 of 1974 issued on 17/11/2003 with the approval of the government is no longer an issue, as the validity of the same has been duly confirmed and accepted as stated above. So, Lordship, it has a long history. Too many facts are involved. That's why, without the support of this synopsis, it will be difficult for the council as well as for the court to have a proper understanding. Now, we have narrated all those things, and that the judgment, the final judgment, has been pronounced in connection with the said suit, and now a challenge to that has been made by the appellants. In fact, the state has no grievance. They have complied with direction of this, the landed trial court. They have issued LSC to both the landowners at this stage. Which does not mean that Lordship it cannot be null if addition is made, other ways. Anyway, grounds of appeal. Number of grounds of appeal have been made, and it has been agitated, and matter has been clearly specified. And
what is the first ground? Denied.
first ground is
Simple denied,
Yes.
but no explanation. So
Yes.
what is ground number 1?
number one is court has seriously wronged in law and in fact while passing the present impugned judgment and order dated 17/5/2023 at page 930. That's it.
Page?
930. At the bottom of page 930, first ground is there. And ground number 2 is that after learned trial court has wrongly proceeded the case after remanded back by Gauti High Court, Aizawl Bench, White Order dated 16/9/2021 in RFA number 16 of 2020, without following the procedure of the Code of Civil Procedure 1908. Direction has been given by the court to implead the present appellants in the civil suit number 59 of 2016 and allowed them to submit their written statement within the specific period. The appellants may also be allowed to cross-examine the witnesses. Trial court decide to retain or rely upon the evidences of witnesses already recorded by the trial court. However, learned trial court goes beyond the direction given by the Honorable High Court, though High Court allowed to implead the appellants as party in the civil suit. But no direction has been given by the Honorable Court to develop the plaint, incorporating some new development and documents. However, the plaintiffs submitted their recast plaint before the court by changing almost all the stands taken by the plaintiffs without prior permission from the Honorable Court as well as from the trial court. The plaintiffs never ever filed any miscellaneous application to amend her plaint before trial court for recasting her plaint. Meanwhile, Honorable High Court only allowed to implead appellants in the suit. Appellants also raised objection in the written statement and challenged the legality and maintainability of the said recast plaint. However, learned trial court turned his deaf ear in this regard. As such, the impugned judgment and order dated 17/5/2023 is liable to be set aside and quashed due to the learned trial court does not follow the Honorable High Court order as well as CPC 1908 for pursuing the suit. As such, the present judgment and order is liable to be set aside and quashed. In this connection, we have taken a very short reply. The fact that after the case was remanded back by the Gauhati High Court by its order dated 16/9/2021, passed in RFA 16 of 2020, appellants were impleaded as defendants number 6 and 7. Accordingly, in view of Order 1, Rule 10, Subclause 4, CPC, the plaintiff was allowed to amend her plaint.
What does it say? Order
may
1
I
Rule
take-
10, 4.
Yes. I'll just read, Your Lordship.
Yes.
Where defendant added, plaint to be amended. Where a defendant is added, the plaint shall, unless the court otherwise directs, be amended in such manner as may be necessary, and amended copies of the summons and of the plaint shall be served on the new defendant, and if the court thinks fit, on the original defendant. So, Lordship, be amended in such manner as may be necessary. When we implead the defendants number 6 and 7, the appellants, the matter which was not earlier required needs to be incorporated in the plaint, and as required by their presence, because they have been a party now, so some direction needs to be made against them, and for that purpose, amendment was necessitated. And accordingly, amendment of the amended and recast plaint was submitted.
But the subject matter will still be the same over the disputed property,
Yes,
isn't
yes,
it?
yes. Your Lordship, this is an order passed by the Learned Trial Court on 4/10/2021. It will be there in the case record also. 4/10/2021.
TCR. Was TCR called for? Paper book is there. Was the TCR called for? Anyway, give me a copy or just read it out. What? The TCR has been kept back?
Yes, kept back. It's too bulky as well. It's kept there.
So on your own, whether we need it or not, you didn't think. So TCR was called for, it's available. For here it says for submission of recast amended plaint, isn't it the order?
My lord, we never aware of that order at the time of proceeding.
This is dated 4/10.
4/10/2021. Counsel for the parties are present. Counsel for the plaintiff submits that the Honorable Gauhati High Court Aizawl Bench Fight Order dated 16/9/2021, passed in RFA 16 of 2020, had directed that Union of India, represented by the Secretary Government of India, Ministry of Defence, South Block, New Delhi, and Chief Engineer Project Puspak, BRO, Aizawl, Mizoram, care of 99 APO, are be impleaded as defendants number 6 and 7. Therefore, in view of the order passed by the Honorable Gauhati High Court, Aizawl Bench, Union of India, represented by the Secretary to Government of India, Ministry of Defence, South Block, New Delhi, and Chief Engineer Project Puspak, are impleaded as defendants 6 and 7, and Ms. Zairem Sampui, Lanet CGC, accepts notice on behalf of newly impleaded defendants number 6 and 7. Mr. Zoram Sana further submits that the plaintiff number 2 is no longer interested in the case. As such, he prays for striking off the plaintiff number 2 as a plaintiff in the instant case. Perusal of the order dated 16/9/2021 shows that this court has been directed to make an endeavor to dispose of the instant case as early as possible, and preferably within a period of 1 year, as the matter has been pending for a long time, and the issue at hand with regard to the stand of defendants number 6 and 7 being very specific nature, as such, the plaintiffs are directed to submit the recast plaint or amended plaint as per Order 1, Rule 10, Subclause 4, CPC. Further, prayer of the counsel for the plaintiff for striking off the plaintiff number 2 is heard and allowed. Hence, the plaintiff number 2 is struck off as a party in the instant case. Fixed 18/10/2021 for submission of recast or amended plaint. So this is the order, and accordingly we had submitted the recast plaint. And now simply the appellants are simply questioning the amendment which has been made and which was necessitated by the impleadment. On the impleadment, amendment of some portion of the plaint was necessary. And this what was provided under the said provision of the CPC. Order 10,
Okay.
Rule 4.
So the next
Order
ground.
1, Rule 10, Subclause 4. And next is, suit ought to have been dismissed in limine as being time barred inasmuch as the suit was filed in the year 2016, whereas the allegation made in the plaint at para 38 of the rental compensation, 38, for that rental compensation has been claimed by respondent number 1, plaintiff, with effect from 1/6/1963 till it is vacated or acquired as per law. However, the respondent number 1, plaintiff, was filed a suit after a lapse of 53 years from the date of occupation of the land in question by the present appellants. Meanwhile, acquisition of land in question has already been done in the year 1989. Void award number 9 of 1989. Given these circumstances, the suit should have been dismissed as being time barred. However, the learned trial court has simply held that the present appellants, defendants number 6 and 7, could not have arisen in any manner regarding the question of limitation, doctrine of estoppel acquisitions. As such, the issue is decided in favor of the plaintiffs. Hence, learned trial court has erred in law, and as such, the impugned judgment and order is liable to be set aside. Cost. In this connection, Your Lordship, we understand of the respondents number 1 and 2 is that there is no such delay. The plaintiff here, in a response to appeal ground number 3, we have stated that the plaintiff had challenged the order dated 24/11/2015, passed by defendant number 2, that is the Secretary to the Government of Mizoram, Land Revenue and Settlement, cancelling permit number 191 of 1974 without issuing any notice to the landowners. Therefore, the question of limitation could not arise inasmuch as the suit was filed in the year 2016. So far as the claim for rental compensation is concerned, the assessment for rental compensation was forwarded to the defendant number 7 by defendant number 2, void letter dated 25/11/2009, and since the amount was not paid by the said defendant, defendant number 2 had again forwarded letter dated 1/9/2010, requesting for payment of rental charge, clearly clarifying as to how permit number 191 of 74 was never acquired by the BRTF or Project Puspa, and while accepting genuineness of the permit number 190 of 1974, genuineness of permit number 190 of 1974 cannot be challenged, as both the permits were issued by bifurcating permit number 682 of 1963. Moreover, minutes of the meeting held in Chamber of Secretary, Land Revenue and Settlement in connection with the claimed areas within BRTF occupied area at Zemabo, Tuampui, on 16/9/2014 at 11 a.m. clearly shows in serial number 1 that assessment prepared and sent, void letter dated 1/9/2010, was to be submitted, and if the land is no longer required by BRTF, the land may be handed over to the landowner. Said meeting was attended by representatives of the defendants number 6 and 7, and no objection was raised. Therefore, defendants number 6 and 7 are stopped from denying the claim of rental compensation at this stage. If I take lordship to
This
the
one,
page.
dated 01/09/2010.
Yes,
Page
42 for 42. Lordship 432 in the second book. It's a letter dated 29/11/2009.
432.
Yes,
25th
432.
11/2009. What about this letter 01/09/2010?
The subsequent letter, Your Lordship. One 9/2010 is also there. May I take Lordship first to Exhibit P36 at page 42. This is a letter from the Undersecretary, Government of Mizoram, Revenue Department, regarding payment of rental charges for occupation of private land at Zemabo, an abstract of final report on demarcation, verification of BRTF acquired area at Zemabo, block number 3. With reference to the above subject, I am directed to submit herewith an abstract final report on demarcation, verification of BRTF acquired area at Zemabo, block number 3 for final lease. I am further directed to state that rental charges amounting to rupees 8 crore 70 lakh 1,699 may kindly be cleared immediately. You may write to Government of Mizoram in case you require the land in future for acquisition, or you may hire the land to the landowner after payment of rental charges. Lease cannot be considered for block number 3 without fulfilling the above rental claims and acquisition of the land. So this has a clear indication that even the BRTF had sought for leasing, but it was under consideration, and they said that first pay the rental compensation which is pending. Thereafter, lease may be considered. Here it says, lease cannot be considered for block 3 without fulfilling the above rental claims and acquisition of the land. And abstract final report is at page 433, wherein the block 3 has been clearly specified. This is a letter dated 21st July 2009. In pursuance of the above order, a joint team of verification visited the site on 29/7/2009 and decided that ground demarcation was entrusted to the Tuampui Cadastral Survey team leader under Lalsiam Liena. Surveyors are instructed to make demarcation as per the acquired map and also to locate road and stream structures as well as private land holdings within the acquired map and to list out names of private landholders. Block 3. Whole area of Block 3 was claimed by the Antudai with permit number 191 of 74 and District Council passed garden number so and so. The same area was fully occupied by BRTF. This land was not acquired by the government and was not included in the word number 9 of 1989. There is no valid pass nor lease document submitted by the Chief Engineer BRTF, but as desired by the Chief Engineer, Block 3 was included in the proposed lease of BRTF. As it learned that the rental claim by Lientudaya, son of its Tanzava, Lientudaya, father of, it should be,
Son of H. Tanzava.
Lientidaya's son, H. Tanzava, was considered by the government of Mizoram after verification. As claimed by Lientudaya, rental charge sanction proposal was moved to Government of India through the CE Project Puspak Zembok by Government of Mizoram on 17/1/2004 and reminder on 15 October 2008. Matter may be decided by Government of Mizoram, Government of India. All claims for individuals which fall within the proposed PRTF land lease area are being verified from office record final report is submitted herewith for final decision of Government of Mizoram. So the rental calculation assessment there, and the total has come to 870,01699. And by another letter dated 1/9/2010 at page 46, Your Lordship. By the same authority, Under Secretary, Government of Mizoram Revenue Department. So
Now, this was exhibited by whom before the trial court?
it is exhibit 36, exhibit
So
37.
it must have been exhibited by the plaintiffs.
Yes, yes.
Plaintiffs exhibit, isn't it? Huh?
It's a government letter addressed to the Director General Border Roads, New Delhi, for payment of the said amount that has been assessed. Details are here. Should I read, Your Lordship?
No, not really. Basically, a rental
Yes.
amount totaling to 8 crores.
Since Liantudaya died on 22/1986, his son, namely H. Tanzava, is the legal
So
heir.
read this part, 437, while considering the matter.
Yes.
The following may be taken into account. Maybe this
Number
part
one,
will be
yes,
important.
Lordship. Liantudaya laid on a plot of land at Zembo given by the Lusai chief of Durtlam. Land was converted into garden permit number 682 of 63 in the year 1963 by the erstwhile district council. 2. Garden permit number 682 of 63 was bifurcated into 2 permits, such as 190/74 and 191/74 by the Revenue Department, Government of Mizoram, copies enclosed. Reason for this bifurcation was that Aizol Lunglei Road was constructed across the area of garden permit number 682 of 1963. The entire land covered by permit number 190/74 was within fencing made by BRTF Project Puspak, but land was not acquired by BRTF Project Puspak, and the landowner did not receive compensation for his plot of land. Copy of certificate. Therefore, the land under permit number 190 of 74 was released to the landowner, named Lilian Tudaya, on 7/12/2001. The land under permit number 191/74 has been occupied by BRTF of Project Puspak since 1963. From that time onward, the landowner, Yantudai, was deprived of all his rights over the land and forced him to move to interior village called Saitwal village. Entire land under permit number 191/74 is shown as Block 3 in Puspak acquired land. Hospital works quarters and chief engineer's quarters were constructed and presently being occupied by BRTF Project Puspak.
So, 191 is shown as block 3.
Yes.
Acquired land. So what
Shown
does
to
this
be
mean?
acquired land. It was shown as government wasteland. Para 5 will indicate more clearly.
Yes.
Revenue Department Government have conveyed approval for conversion of permit number 191 of 74 into house site, right number so 2002. However, conversion of garden pass into house site could not be taken up since the area under permit number 191/74 is still under occupation of BRTF Project Puspak. Therefore, the land covered by permit number 191/74, termed as government wasteland by the chief engineer in his letter dated 14/12/2009, was found not convincing. Further, while accepting the genuineness of permit number 190 of 74, genuineness of permit number 191 of 74 cannot be challenged, as both the permits were issued on the strength of permit number 682 of 1963. 6. The area of land under permit number 19174 was entered as 2 bighas. However, representatives of Revenue Department and Project Puspak conducted joint spot verification to ascertain the exact area of the land on 24/3/2003. It found that the area covered by permit number 19174 is 29.48 bighas. The demarcated area of 29.48 bighas was approved by the government of Mizoram, white numbers and so dated 14/10/2003. Copy enclosed at Annexure 17. And that permit number 191 of 74 was corrected and reissued accordingly. The land measuring 53.83 acres or 161.5 bighas located near Zembok village was acquired by the government of Mizoram for public purpose, namely for office complex of Project Puspak in the year 1989-90 under Land Acquisition Act 1894. The acquired area was divided into 5 blocks such as 1, 2, 3, 4, and 5. Land covered by permit number 191 was shown as block 3 in the acquired land. Draft award number 9 of 1989 was submitted to Revenue Department, Government of Mizoram by Land Acquisition Collector, ISO. And the award was approved by the Revenue Government of Mizoram. The land covered by permit number 191 of 74 was not shown in the draft award number 9 of 1989. Hence, the land covered by permit number 19174 occupied by Project Puspak appeared not to have been acquired by the government of Mizoram for office complex of Project Puspak of BRTF, as the land was not shown in draft award 9 of 1989, as well as the name of the landowner Lientudaya was not figured in the acquired landowner list, and also no compensation was given to him. Since Lientudaya died on 22/1986, his son, namely Tanzawa, is a legal heir. It is therefore requested that immediate action may be taken for payment of rental charges amounting to 8 crore something for the period from 1/6/1963 to 31/12/2009. Lordship,
This is the state's observation, isn't
yes,
it?
this is the stand of the state government.
This is 2010.
And at page 440, lecture 37, exhibit P38, these are minutes of the meeting held in the Chamber of Secretary, Revenue Department, in connection with claim areas within BRTF area Zembok Tuampui on 16/9/2014. Meeting was presided over by Secretary. Claims of 3 persons, namely Lientudaya, Ropira, and Ralkaptanga, whose lands located at Tuampui Zembok, was discussed in detail. Minutes of the meeting held on 4/2/2014 was again gone through. On close perusal of site plan and detailed discussion, the conclusion of its case by the meeting is as under. Lientudaya's land. BR number 1. The BRTF authorities were asked several times to pay rental compensation to Lientudaya as no payment had been received by him till date. Assessment prepared and sent white letter number dated 1/9/2010 may be resubmitted. If the land is no longer required by BRTF authorities, land may be handed over to the landowner. The other two are, and the list of attendants at page 442.
So
And at serial number 3 is
she is whom?
Comment
Okay.
KS.
BRTF.
Yes, BRTF. Representative of Puspak.
Okay. Then
Lots
maybe
of-
we can continue your page 7,
Yes.
number 4.
Appeal ground number 4 is that the learned trial court had made an endeavor to dispose of the case within a period of 1 year. However, the same had been done within 1 year, 5 months, since there was no mandatory time frame fixed by the government of Guwahati High Court. There is no disobedience on the part of the trial court in disposing of the case. So, this should not come as a ground of appeal,
This
but
not-
it has come. Anyway.
Anyway, number 5.
And appeal number 5 is the plaintiff had purchased the suit land from defendant number 1, who is the legal heir of deceased Liantu Daya, after heirship certificate number so-and-so dated 14/3/2000 was duly issued by the Sub-District Council Court. In fact, sale deed has been duly executed and registered as par law. Therefore, the plaintiff has locus standi to file. What they have stated is that the plaintiff has no locus standi because of the fact that the permit was the permit number 191 of 1974 was in name of Liantu Daya. So, sale deed was executed with the legal heir of the deceased Liantu Daya. Appeal ground number 6 was what we had
Already
stated.
discussed, isn't
Yes.
it?
And ground number 7
We page those grounds. What was the page? I think we noted somewhere. Page 931. 930, 931.
937 is at 935. That's it. Here it says, Learned Trial Court ought to have dismissed the suit inasmuch as no cause of action has been arisen against Union of India. There is nothing in the court to show that defendant number 6 and 7 occupied the land covered by permit number 191 of 1974. And there is also nothing in the deposition of all witnesses before the court to show that the permit number 191 of 74 is under occupation of the Union of India. Plaintiff also not paid for anything from Union of India in the old claim and also not made as a party in the suit, which shows that land in question is not occupied by Union of India. The same also known very well by the plaintiff from the beginning. The issue in the whole claim is solely between the plaintiff and the defendant number 1 only. As such, the suit ought to have been dismissed due to no cause of action against Union of India. Only cause of action against Union of India at this stage is that since they are occupying the land in question without any allotment having been made and without any acquisition proceeding having been drawn in that particular plot of land, they are now occupying without paying any rental compensation to the landowners. Now, finding has been made by the state government authorities concerned in the presence of the representatives of the BRTF. Now that it was found that they are occupying that portion of land and the rental compensation has been assessed, and now it is the duty to make payment of the said assessed amount. This is as simple as that, Your Lordship. Ground number 8, trial court has specifically dealt with all the issues framed and there is no error in law in passing judgment and order dated 17. 9 is on the learned trial court ought to have dismissed the suit inasmuch as the plaintiff failed to comply with section 80 CPC of filing a suit against Union of India. Lordship, at this stage, since there was a direction from the Honorable High Court at the time of remanding the matter back to the land trial court, there was direction to the effect that the respondents, who were the appellants at that point of time also, they should be pleaded as respondents 6 and 7. That was very clear. And whether it would be necessary to issue a notice under Section 80 CPC. That is the issue. Now that they have raised Section 80 CPC was not complied with. But in view of the direction of this Honorable Court, matter was taken up and the
Okay.
80 CPC was not required anymore. Since they were already party, they have implemented themselves, in fact, by filing an appeal. Ground number 10, heirship certificate was issued to defendant number 1 in respect of all the properties left behind by Lian Tudaya, deceased. Deceased was the owner of permit number 191 of 1974 and had sold some portion of his land to Bielzava. Area of land sold to Bielzava was converted to Pipata number 1 of 1977 with an area of 2 bighas, which was subsequently converted to LSC number 10385. The same was acquired by BRT of right of word number 9 of 1989. However, the remaining area of land covered by permit number 191 of 1974 was retained by Lian Tudai, and the same has also been converted into Pipata number 57 of 1995. However, it was reverted back to its original status as permit number 191 of 74, void order dated 3/10/1997, issued by the SO1 Land Revenue Settlement, as said land was within Aizawl town area. In this case, exhibit P35 at page 430 may be seen, that's it. .30. .431 is a translation. May I read, Lordship?
Yes, please.
This is exhibit 35. In reference to court order number 27194 concerning the land at Aizawl Road located on boundary between Zembok and Tuampui belonging to Mr. Lian Tudai of Zembok, care of Mr. Laltan Aze Pacho Mission Veng, converted permit number 190 and 91 of 74 to Pipata number 4 and 57 of 1995. Conversion of permit number 190 of 91 of 1974 to Pipata of 4, number 4 and 57 of 95 as per court order number 27194 is hereby cancelled, since it is covered under Aizawl town area. Pipata number 4 and 57 of 95 is to be reverted back to its original status, which is permit. Consequently, garden permit number 190 and 91 of 1974 is returned to Mr. Lian Tudai of Zembok, care of Mr. Laltan Aze Pacho Mission Veng. Mr. Lian Tudai of Zembok, care of Lian Tudai Laltan Aze Pacho, is required to submit Pipata number 4 and 57 of 95 back to the undersigned within 10 days from issuance of this order. So, Lordship, this is a letter issued by the SO1. They have followed all the formalities, all the procedures of the law in reverting it back to a Pipata, permit. Appeal ground number 11. At page 940, Your Lordship. For that, the Lanet trial court has wrongly held that issue number 8, that is, whether defendant number 1 had sold his land covered by permit number 191 of 74 to the plaintiff at any point of time by executing Indemnithutlung dated 12/4/2022. A sale deed dated 19/11/2013, if so, whether the said Indemnithutlung and said sale deed are valid in the eye of law, partly in favor of the plaintiff. Learned Trial Court further stated that the contents of Indemnithutlung dated 12/4/2002. 12/4/2002. The above one is also 12/4/2002, not 22. Being not disputed, the same is decided as valid in the eye of law by ignoring the stand taken by defendant number 1, namely Sri Tanzawa, at his written statement at para 10. That is, the stand has been quoted. The contents of para 5 is utterly false and sheer concoction. It is reiterated that defendant number 1 has never sold his land covered by. These are all the matters between the plaintiff and the defendant number 1, who are on one side now, on the same side. Now that it is.
Also, she had mentioned that previously in the examination in chief,
Yes.
he had denied the Indemnithutlung, etc.
Yes.
Then later in the cross, he
Examination.
had changed his stand.
Yes. So he had taken a U-turn, and it appears that they are joining hands
Now,
during
at
the
this
course of
stage,
the proceeding.
So she had, that was one point she had
However,
raised with
Lordship-
some judgments.
Yes. Your Lordship, that does not prejudice the cause of the appellant in any manner. They are
Anyways,
the respondents 1 and 2 are the enemies of the appellant.
Previously
the appellants.
enemies, now friends.
They
Same,
were-
now
they were
common
having-
enemy. Now
they
they
were
have a
having-
common enemy, so they've
Yes.
become friends.
They were having intra-fighting earlier, but in the meantime, they have come to a settlement. And
Okay.
that hurts, it appears, that hurts the appellant. But
Anyway, so-
I don't know how that can be a prejudice to the cause of the appellant in any way. It does not matter whether the whole land has been taken away by the defendant, number 1, or taken away by the plaintiff. If both parties agree, that cannot be agitated by the appellant in any manner.
Okay, it's next point.
Round number 12.
There's no 12, there's no 13.
No, no 12.
No 12, no 13.
Yes, even in our synopsis, we have stated that appeal ground number 12. There's no ground number 12 in the memorandum of appeal. However, ground number 13 is there.
Where's 13 page?
13 is 945.
945, okay.
What we have stated against the ground number 13, let me first see. For that, Learned Trial Court has wrongly declared that reissuance of permit number 191 of 1974 by increasing the area of the said permit from 2 bigas to 29.48 bigas, which was approved by the government by letter number so and so, was valid. That was the finding of the Learned Trial Court. In fact, permit number 191 of 74 reissued on 17/11/2003 is to be held invalid while deciding issue number 9, whether permit number 191 of 74 reissued on 17/11/2003 by the state defendants is valid or not. However, the Learned Trial Court did not discuss about the conversion of the said permit number 191 of 74 from an area of 2 bigas to 29.48 bigas, which was later on revoked by the state government themselves.
Okay,
also-
this is the impugned letter,
Yes.
24th November.
which was issued by Zoltan Kumase 3, and the same was issued, was The same issue was the main challenge by the plaintiff in civil suit number 59 of 2016. However, without considering the region where reissued, the permit number 191 of 74 later has been revoked by state government, even though the state government themselves already revoked issuance of permit number 191 of 74. However, Lanet trial court need not take into account all the evidence and available documents on record. Contents of the said order they reproduce herein. So, in sum and substance,
This is
What?
2015, but after 2015?
yes, this is
there were other
2015.
letters,
Now, we are in 2023. What has been challenged is of 2023 judgment. It's a very long ground, Your Lordship, till page 951. This, the quoted judgment,
I think this is the main case, the whole thing about the appeal.
this could have been the main case of the government. Government, that means the state government, because their order was under challenge, and now the state government is to make a challenge if they are aggrieved with that. But when the state government, that is the author of that order, is keeping silent and is not making any challenge, how can the right to challenge come over to the appellant? The appellant is simply occupying the land of the plaintiff and the defendant number one. Now that the judgment was passed, even in the earlier
Setting
round,
aside 24/11, 2015, isn't it?
that was not challenged by the state government, and the matter was taken up by the appellants by filing appeal before this honorable court. The matter was remanded back here to the trial court, and fresh adjudication was made. And now, when it was adjudicated upon, the state government did not raise any grievance against that judgment and order. And in fact, as already read out during cross-examination, even the witnesses for the defendants number 6 and 7, they had stated that we're not aggrieved by the order portion. We're not aggrieved by the order portion of
the
that
court,
2000, yes, which is at page 40. So when they were not aggrieved by the order portion, even in the earlier round of litigation, now they are stopped from raising any such.
Now, after 2015, was there any other verification done?
After 2015,
24/11, 2015.
yes, as directed by the court, there was
Something
a
was-
verification report was made.
There, the bigas
Latif,
was found, isn't it, to be
Yes,
20 to
20
something,
bigas.
20 bigas.
After excluding the lands acquired by the BRTF, which was earlier sold to Mr. Bielzal. So the area has been the area has been decreased from 29.48 to 20.2 bigas.
So
Appeal ground
this
number 3,
permit, wait, permit 191 was revoked. And then again later it was reissued, isn't it?
Yes.
Oh.
it was reissued,
So 191
and
is
that has
now in
been
existence.
again cancelled by the impugned order.
Oh.
That was challenged and set at rest. Matter was set at rest. So far as the said matter is concerned, if I take a lordship to page 977.
Anyway, it's going to be time for a lunch break.
Yes.
So this is the main thing we have to look into, the
Mr. Lordship, just before this
number 13, and you can explain number 13, the
Yes.
grounds number 13, though you have more or less discussed. If you want, you can revise that after lunch.
All right.
14 is not so much. 13 is the main, this thing. 13 and maybe 14 also. Thirteen and 14, those are the grounds taken. Of course, there will be a repetition. You can say that I've explained this here. So we can, yes, so we can finish this today.
Yes, yes.
We'll continue at 2.